Hello everyone, this is Sachin Sawant, your UK immigration lawyer. Now I'm live on YouTube. This will be saved and published on YouTube as well as TikTok. I will try to start. If you all have any questions, please to ask. Type in the comments and ask for. I will try and answer to the best. Right now, I will go over the YouTube comments. There are several questions on various videos. I'll take them one at a time and try to answer. And whoever has asked those questions, they can see this live and get the answers. So I'm going in the reverse order. The latest comment that I see on the channel is from Bob14714. Now his question is, my question was that I wanted to bring my wife from Pakistan, but I'm a social funds income support. I'm on personal independence payment. What is my requirements to bring my wife from Pakistan? PIP is another word for disability. Yeah, I know what PIP is. So, PIP, if you are receiving PIP, yes, you don't need to meet the financial requirement. However, there is another maintenance and accommodation requirement. You should have enough accommodation to accommodate that person that you're bringing in, your partner. And there is a quite a complex calculation. You will have to basically book a consultation with us and we can calculate your current incomes, and only then we'll be able to tell you if your income from benefits, etc., does it qualify you to sponsor her or not. So yes, it's a very specific case specific advice. We have to see the amounts and see how many members are there, calculate it, and only then we can advise. So that's the answer for that one. But yes, the summary answer is that yes, it is possible to sponsor. Uh, and yeah, that's it. So you can sponsor your wife. However, the calculation is quite complex. Do book a consultation and then we can calculate your exact incomes from PIP and various other benefits that you get. So you don't have to meet the financial requirement if you are getting one of the benefits. One of them is PIP. Okay. The next question on, I'm taking the questions on YouTube channel. So I think whoever has joined now. Uh, so another question from Ramon Thomas. What if the 60 days pass? Will they notify you? So this is the question on the video. What can I do if I am being made redundant? So an individual is on a skilled worker visa, made redundant. They have 60 days. The video details everything else. So they would ideally have 60 days to switch to another category or leave the UK. So I think the individual's Ramon's question is, what if the 60 days pass? Will they notify you to leave? So I have summarily answered it over there. I'll elaborate on that over here. So once you get the curtailment letter, after that, there will be no other notifications that you will get. That is the final notification. You have to do something within the 60 days. Next question on the YouTube channel that I have. Okay, can you please guide what's the from NAV NAV 196? Can you please guide what's the timeline for issuing costs for defined and undefined? So yes, the defined costs, usual timelines between most of the costs that we get is within 24 hours of filing. Worst case scenario, if they ask for further information and all, usually within 5 business days, we have been able to get a defined cost. Defined cost is for someone who is applicant is outside the UK applying for an entry clearance. Undefined costs, usually the sponsor should have allocations, the certificates already sitting in their license sponsor management system. They can allocate instantly if they have a certificate. For someone who is inside the UK, undefined certificates, they sit in the, you don't have to apply for every migrant. If you have a certificate, they can assign it. If not, they have to apply for additional costs, in-year costs allocations, and give the business case why they want it, whatever that is, business expansion, etc. They may be requested documents, and the standard processing would be 18 weeks from the date of submission, uh, and that is yeah, through the sponsor change of circumstances. And there is also a priority service which you have to apply, and if you get it, usually we do get it for our clients, you pay £200 extra on top of the normal fees and get it in 5 working days. So On the priority service, you can get the undefined cost in 5 working days. Under standard, 18 weeks. Yeah. The next question is for VFS appointment, what does the person have to take? So he's asked in Hindi. So for VFS websites, you can upload all the documents on the website. If you have any challenges, that is our suggestion. Always do upload the documents. Don't trust the VFS executives. Yeah. So uh, we always prefer to upload, and that's our suggestion. And once you've uploaded the documents on the VFS website, then you don't have to carry them with you. You only need to carry is the document checklist, which you will get it after you submit the application form. The system will say download application checklist. You print that checklist. Along with that, you have to sign that checklist in front of the VFS executive. So remember that that's a VFS requirement. So don't sign it before. Take it to them. They will ask you to sign wherever. Also, the checklist is not 100%. Just to add on the checklist point, it doesn't cover the whole aspect of immigration rules. It's just a standard. So we don't trust the checklist as well. You have to go by the immigration rules. Or there are various list of documents on our website for different types of visas. You can look at them and arrange those documents and submit them. And appointment confirmation. So three things you need: the appointment confirmation of VFS. Second is the checklist that you download and print out and sign in front of the VFS executive. Don't sign before, yeah, they may ask you to sign again. And also your original passport. And to add on that, if you have the option of getting the passport return service, keep your passport. They may charge some additional fees and they may return your passport. So that is all done by the VFS. So secondly, the next question, NBEN 5325. Because, yeah, what is the cost of ILR on the 10-year route? That's what the individual is asking summarily. So it's 2,404 for a standard decision. Okay, the next question. Okay. Yeah, so I'll just summarize the question over here. It's quite in detail. So the individual user HP4ZB4GU3C is asking whether he has to pay. So he's meeting the financial requirement to sponsor a partner, I think, or anything under family road if you're sponsoring someone. And to meet the financial requirement, he is going to use his self-employment income. So for that, I think the summary of the question is, can I submit the small statement before I pay any taxes? So I think he's asking before submission of the application, does he need to pay the taxes? So the rules state that evidence of the amount of tax payable and unpaid for the last full financial year has to be submitted. So ideally, we always advise our clients to pay the tax, whatever is due, whatever financial year they are using in their to meet the financial requirement. It is always advisable to pay whatever taxes are there. And if there are any unpaid, make sure you put all the proof of HMRC statements showing that it is not yet due. So next question is, so I started my job 7 months ago. Yeah, so the person Zaka2091 says, I started my job 7 months ago. Same employer. My annual salary is 19,200, 1580 per month. I only have 7 payments so far. And so what do I have to show now? Yeah, so there is a detailed video on what documentation is required. On the website, we have list of documents for sponsoring partners, spouses, parents, fiancés. You can look that. Also on YouTube, we have videos. Uh, it explains all the documents. There are three parts of the videos, part 1 to 3. Name of the video is list of documents for UK spouse, partner, or fiance visa from overseas. That will tell you the documentation required for that question. So it's mainly summarily a letter from employer confirming your employment, the video, and it tells you what format the letter has to be. and that format is also on our website in the list of documents. And payslips for at least last 6 months showing the payments going into your account, and the bank statement showing the payments have been paid into your account. So payslips, bank statements showing last 6 months of payments, and letter from employer. Summarily, you can add extra things. P60 is contract of employment. That helps, but those are not required by immigration rules. But it helps just to build up confidence. Yeah. Next question I see at NBNU1PN. Will like to ask requirements for retained rights. Yeah, so retained rights. So what is retained rights? So an individual who is a non-European national married to a European national, whether or not before or after Brexit. So, but I think for this individual, he is trying to claim retained rights. He definitely has pre-settled status as a family member, as a spouse of a EU national. So his question is, so they are divorced, and what is the requirement for him to retain his rights? What is the meaning of retain? He retains his right to live in the UK, and he can continue to live and complete 5 years and then apply for settlement even if he is divorced. So there are three conditions that need to be satisfied for retained rights after divorce if you want to qualify for settled status. All of the following conditions should be satisfied. Marriage should have lasted for at least 3 years. So, on the date of your divorce, at least 3 years of marriage should have been passed. Number one. Number two, out of those 3 years, you and your partner should have lived together in the UK for at least 1 year. So, minimum 3 years of marriage, and out of those 3 years, minimum 1 year, the couple, both of you should have lived in the UK for at least 1 year. And at the time of divorce, the third one, this is where many applicants do fail. I've seen that when we file many applications even before under the EA regulations, uh, which was exactly on similar lines, and now it has been copied into EU settlement scheme. At the time of divorce, you should have been living in the UK. So that is very, very important. The applicant should have been living in the UK at the time of divorce. So that's an important requirement. Uh, Next question. Can I have contact number basis whether I can apply for ILR and no changes? Sure. Yeah, contact numbers, just go to our website. There is an 020 number. You can call on that. That is our usual office number. We usually charge for our advice. So, yeah, if you want any legal advice, we don't provide free advice. We do charge for our services. So, you can book the consultation also online. It is on the website under the YouTube. Under this video, also, you will find the links where you can book. It's on our website, or you can call the office and someone will guide you through. I have contact number. So the next question is from Sambha1043. I have overstayed for 83 days in the UK and left my home country. In future, if I want to come to UK as a tourist or student, will my visa get refused? Yeah, interesting question. Yeah, I have been asked this quite frequently. So the answer is you will be banned from the UK from applying for any UK visa for a period of 1 year from the date you left the UK. So if there is an overstay of more than 28 days, that's how the rules say. He has overstayed for 83 days. If an individual has overstayed for more than 28 days in the UK, then he cannot apply for any UK visa for up to a period of 1 year from the date he left the UK. Number one. And after that 1 year, he can file any applications on its own merits. It will be decided. And yeah, so that's it. So that's the 1 year ban period. And if you leave as with your own cost, you don't take public funds or anything, the government doesn't deport you, there is no administrative removal, then it is a 12-month ban to apply for any UK visa. Okay. Then, if I'm inside the UK on a student visa, currently on vacation in home country, can I apply for visa? Home country, I'm currently waiting costs. Yeah, so the question, I'll just summarize. If I'm in the UK on a student visa, currently on vacation, so the individual is a student in the UK, has gone on vacation back to his home country, can apply for the visa from the home country. From the home country. Yes, you can, but I think it's not advisable They're really waiting for cost because usually employers will not give a defined cost. If they know that the person already has a student leave in the UK, they will usually get the exemptions. So if it is a shortage occupation, it doesn't matter. I think they wouldn't pay the immigration sales charge. That's how I understand it. But then if it's a normal occupation which is not in shortage, then the employer will always prefer to give you an undefined cost because they know you are a student and on that basis they have offered you the position. So either you are going to complete a degree or you just completed your degree. So it is always advisable to switch inside UK. However, if the individual is on shortage occupation, then it wouldn't matter because they wouldn't pay the ISC. They can give a defined cost. This is slightly complex, but defined and undefined cost. But to answer this person's questions, if he is on a shortage occupation, yes, he can apply from outside UK with the defined cost. The employers will not end up with any extra cost. But if it's not in shortage occupation, but the employer may have to pay ISC, immigration skills charge, on top of all the other fees if they give for a normal occupation, not a shortage occupation, and they issue a defined cost. Because since he's a student and if he switches inside UK, then there won't be ISC. Yes. So depending on it, you can apply anywhere. Summarily, doesn't matter. You can do an entry clearance with a defined cost or come back to the UK and switch from student to the skilled worker. Yeah, so the Kirat 9261 has asked how much UK embassy take time in nowadays after biometric work visa standard service. Hmm. Yeah, for the work visa, it is about 10 working days. That's the standard processing in most of the almost all the countries that we get. Uh, okay, so this is about the next question from Saish Metar 7263 is how do they calculate the pay if we are paid weekly? Do they, so it's talking of maybe a spouse visa or a partner visa or fiance visa where he's trying to meet the financial requirement paid weekly. Do they take the average of the last 6 months, then multiply by 12 months, or do they take the lowest pay slip of last 6 months and multiply by 12? Okay, so the answer is the way they calculate the weekly pay slips. Actual total gross weekly pay received is divided by the number of weeks it was earned over to get the gross weekly income figure. So, for example, over the last 6 months, just taking an example, if you got an X amount, whatever that is, uh, so I've also taken an example and then this multiplier. So let's say the total gross weekly wages is 14,000 over the last 30 weeks. If this person has earned, I'm just taking an example to explain here. So 14,000 earned over the gross amount before tax, that is on your payslip. 14,000 earned over 30 weeks. Then the formula will be 14,000 divided by 30. So that will be gross weekly income figure. It will be average of the weekly income and multiply by 52. So whatever you earned, how much ever pay slips you are showing them, you may be showing them 30 months or you may be showing them the whole 52 months, 52 weeks, 30 weeks or 52 weeks, doesn't matter. They will do an average of the amount, the total gross amounts on all the pay slips. Let's say you give them for 30 weeks of pay slips, the total comes to, gross total comes to 14,000. 14,000 divided by 30, that comes, that's an average of weekly income, average weekly income, and then multiply that weekly income by 52. That's how the answer will be arrived at. Yeah, so, and the question from Sanjeev 1980. My parents will be traveling to the UK this month for the first time. They have a standard 6 month visa. They have a application to travel. Okay. Okay, so parents traveling from India to the UK to visit maybe family members. So Sanjeev may be on some type of a visa or they may be British citizens, etc. Parents visiting them. They applied for a visitor visa, and on the visitor visa application, there are specific questions. When will you enter the UK? When will you leave the UK? What are your travel plans, etc., etc. So when they filled up the form, the travel plan start date and date was different, and now the actual one is different. So if that happens, just as a good practice, if they are queried by the immigration officer, so when they come to the airport, usually they do question them as to how long you will stay, why are you here, etc. They should have their return ticket. So the first thing the visitors should have is at least a return ticket to show that yes, we are going back on this particular day. And if asked, if they ask further questions of to about the change in the plan, etc., why the dates are different, be able to explain the reason. So whatever is the reason, my visa decision did not come, we had planned, we could not get the flights for this date, whatever is it. So any reasons they have, they should be able to give it. If they have any proof of that, let's say your flight was cancelled, someone was sick and you could not, you had to change the travel plans. Any evidence you have, you should carry it with you. It helps to satisfy the immigration officer for future. And also, so that is for this entry when they are coming with a different travel plan now. And for future applications, this should be explained in covering letter. So if next year, let's say they have a 6 months visitor visa, they come and go now, next year or after 2 years they apply for another visitor visa, they should explain this discrepancy that happened, that we had planned this, however this happened and our plans changed and we traveled on this date and left on this date, something like that. It is a good practice to explain in a covering letter for the subsequent application. You don't want the new caseworker who is looking at the next application to assume anything adverse. All this is a good practice to keep immigration history clean so that your history is clean rather than any further immigration officers, caseworkers assuming otherwise. And next question by Rolling 9077. Is my mic on? Yes. I have plans going to the UK by visit visa in the coming months with my boyfriend. If, I, if by any chance we would want to step in a relation, possible to fiance visa. So this person Ria Hidrolin 9077, she will be traveling to the UK on a visit visa to see her boyfriend. And the question she is asking is if they decide to get married once she is here, can she then apply for a fiance visa from within the UK? The simple answer is no, she cannot. You cannot apply for a fiance visa from inside the UK. It has to be filed from outside the UK. So that is the answer for your question. Uh, Visitors are not allowed to switch into any long-term visa categories. Yeah, usually that is always the case. Next question, mind, body, soul, clean 5643. Okay, contact number. Yeah, you can go to our website for the contact numbers. Okay, if you want us to review any documents, anything that you are talking of, I'm not sure what this person is asking to review, but yeah, we do charge for our consultations. We don't give free legal advice. Uh, if you want us to check any documents, anything, you can book the consultation and take it from there. You can go to our website or under this video and on our YouTube channel, you'll have the phone number, etc., and the links to book the consultation. It's all an automated system. You can book it yourself. What about separate agreement? Okay, it's the same thing, the agreement review. Yeah, this is about employers skilled worker visa clawback clauses. Yeah, so there is a video that I've made on the clawback clauses where employers are trying to, the video details all the things, but briefly, those are employers are trying to take back some fees or some exorbitant amounts if the skilled worker comes to the UK and then resigns or doesn't work for a certain period of time, let's say 2 years, 3 years, 5 years, whatever they write. Such clauses are not allowed. They are. The video will tell you in detail. You can just search for Beware Employers Skilled Worker Visa Clawback Clauses. Are they allowed? That is the name of the piece of the video. Those clauses are not allowed whether you keep it inside the contract or as a side contract. Even if you do it as a side contract, it won't be enforceable even in the employment tribunal. So yeah, just trying to get around may not help. So I think that person is asking, what about a separate agreement from the contract? Whether you put it on the contract or you have a side letter annex, whatever legal document you make, doesn't matter. It is a part and parcel of the main contract. So yeah, I don't think it will help. So clawback clauses are not allowed, whether inside, sitting inside the contract or in any addendum or annexes. Okay, so the next question that I see on our YouTube channel, I'm taking the questions from the YouTube channel. If anyone has any questions, you can type them. I'll be live for 5 more minutes. It's 25 minutes now. So the next question is you really okay. I'll try to summarize the questions. So read okay, some detailed specific question. Hi, Timur. Hi. Yes. Anyone has any questions, you can type them here. I'm taking the questions on our YouTube channel under comments under various videos. I'm just trying to answer them. So someone is asking. So Tahsin Hussain is asking if someone came to the UK as a skilled migrant and his wife gave birth to a child after 2 years. Okay, after 2 years living in the UK, they gave birth to a child. Will the child become British by birth? No, the child does not become British by birth. Uh, British immigration rules, British Citizenship Act 1981, it changed around 1981. Kids don't get it by birth. Child will not be born British. Skilled worker migrant can apply for ILR after 5 years and citizenship after 1 year. So she asked for the questions also when they can apply. How long can skilled migrant need to wait to get ILR and citizenship? So the first question, this is the easy one. Skilled worker migrants after 5 years in the UK, they can. Timur, yeah, I will take your question. First, I will answer this. Uh, Skilled worker migrants need to live in the UK for 5 years. After that, they can apply for ILR. Then, after waiting for further 12 months from the date of ILR, from the date they get the approval email of ILR, they can apply for British citizenship. Timur's question I would like to ask, I have applied for EU pre-settled scheme but refused. Yeah, what is the reason of the refusal? If you can type that. Yeah, so it, mm, yeah, so why it has been refused? Were you living in the UK before the end of the transition period? I need to know the facts of the case. You can file an administrative review. Usually, they will give you the option. It should be in the letter or an appeal, right? You can either do an administrative review, but remember, admin reviews will take up to 12 months for a decision and counting. It may also go higher because they are just too busy with it's really loaded admin review section. Second option, you can leave the admin review, directly go for an appeal. If they have given you a right of appeal, you can do that as well. But yeah, I can only advise on the merits. Yeah, briefly, if you tell me why it has been refused, etc. In the meanwhile, I'm taking the questions on our YouTube channel. No more questions yet. Okay. Yes, if you have joined now, hello, and you can ask any questions here. I'll try to answer them briefly. Can I apply 10-year road spouse visa from India? No. So yeah, Karthik Sundaran 3429 on YouTube channel comments he has asked, can I apply 10-year route? So I think 10-year route to settlement spouse visa from India. No, you cannot apply. It's not an entry clearance application. So there is okay. So Timur says for the pre-settled refusal, there is just said no evidence proved. Yeah, you really need to. Yeah, some lawyer has to assess. So if you want us to assess, you can book a consultation. We can check what evidence you have given, what is that they are saying. Then we can advise you on the merits of success. Just filing an admin review or appeal will not help. So there is a specific list of evidence they always ask for. That's what I've seen. I have many times negotiated. Sometimes they give up, sometimes they don't give up, sometimes you have to go for appeals, etc. But yeah, I need to see the evidence and whether you really have a right as per their books, as per the rules. So yes, do book a consultation with us. We can check what evidence you have provided, what is that they are saying, and then we can advise what are the chances of success, next steps, etc. So yeah, if you want to book the consultation, there will be links below in the video or on our YouTube channel, you'll find it. Yeah, so you can call the office or directly book it online. Okay, the next question. is we actually okay. Yes, Timur. So at v.p982, 3 weeks ago, this is the question. We are in ICT visa. Common question. Intercompany transfer visas not leading to settlement. They will need a solution, I think, for 5 years till 2020. Then switched into skilled worker visa before my previous ICT expired. Okay. Would I be eligible for 10 years route of ILR? Yeah, if you are counting, you are trying to use ICT visa for the 10 years long residence, yes, you can. So, but before that, maybe your 5 year point of your skilled worker may come and you may qualify as a skilled worker on ILR on skilled worker itself in 5 years if you do complete that before. Like help, how can I contact you? Discuss. Okay, so I don't know how to put the numbers here, but yeah, just subscribe to our channel and if you just put in any comments, someone will get back to you from office. So, or you can just on the channel also there is a website link. On the website, if you go, you can book. There is a book online option. You can book the consultation from there, or you can call the office and someone will help you out with that to discuss. Yeah, for the consultation. Yeah. So next is let me find okay. Okay, so from Prabhin Maharjan. How long is it? 31, 39. So me and my wife are planning to apply UK. My wife is student for masters, including me as dependent for September intake. So this September, I think they meant. But we have our 4 months old child. We are thinking to leave him here in Nepal with grandparents. And we can we bring our child after 2024 after finishing my wife's. So yeah, this is a problem. There are dependence restrictions on several visas nowadays, student, graduate route, and all of that. So the answer is you can only bring the child to join the main applicant when the main applicant has a student visa. So this is very, very important. There usually I know students they may have children. The couple may come here, but the child usually in Asia I've seen that India, Pakistan, even Nepal, Bangladesh. So they may keep in Philippines also I've seen the children with their parents or in-laws to take care of them. However, the problem that would come is you can only attach dependents at the first point on the student visa. If you go to a graduate route and then you try to bring your child, you won't be able to attach the child because the graduate route is an in-country application. Unless the main applicant and the dependents are already in the UK on the student and dependent, only then they can switch further and go move on. You cannot add on. So if you keep the child out maybe for 1 year of masters, then on the graduate route also the child will have to be out. Only when you get a long-term visa, say a skilled worker or something, you may be able to sponsor the child into the UK. So it is better for the child to join now, or the child cannot join on the graduate route. Yeah, many people are stuck, even not even child, even for partners, spouses. I know students come to the UK and then after by the time they complete their masters or whatever education they are doing, when they get the graduate route, at that time if they get married, the spouse cannot join the person on the graduate route visa. Only when the student moves on to a long-term visa, say a skilled worker visa, then the spouse can join him or her. So mainly I know I've spoken to many students. Basically you have to avoid getting married during your graduate route period because you cannot bring your partner during the graduate route period. You can bring them when you are a student or after your graduate route ends. Okay, next. So Ernest Buram 2086 is asking, please, how can I request my lost course copy, certificate of sponsorship copy from home office, please? The certificate of sponsorship is issued by the employer, and only the employer can get a copy from the sponsor management system. So if you are the applicant and you use that course for your application, home office may not give you a course copy because the course is a document for the employer. Only the reference number is something that you can use. the employers do share the copies, you can go back to your employer and try to ask them. They can just download it. Usually they will have in their systems if they still have a sponsor license. Other than that, you may not be able to request it from home office. And thank you very much, anyone who joined this live. We'll be uploading this on YouTube as well. So anyone who has asked these questions, they can see all these answers in their own time. Uh, it will also be uploaded on TikTok, etc., other channels. So uh, do subscribe to our channel if you do like this live. If you get any answers from here, definitely subscribe to our channel on YouTube, TikTok, etc., every social platform. And thank you very much for joining.